I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. Think about this, okay? Just suppose, and I hope it never happens to you, that you've been accused of a crime. Your liberty is at stake. The prosecutor's going after you, wants to lock you up. What are you going to do? What are you going to do? You're going to call a lawyer, right? You're going to call a lawyer, and when you're picking your lawyer, what kind of lawyer are you going to look for? You want someone that's going to fight for you. You want someone who's got your back, is going to be a bulldog, a pit bull, inside that courtroom, outside that courtroom, not budging, not giving an inch. Imagine if you're wrongfully accused and you're actually innocent. You want someone that's going to fight hard. Then if you're actually guilty, you probably want someone who's going to fight even harder for you. That's the nature that's human nature. I mean, the only thing standing between you and prison is your lawyer convincing a jury not to send you there. So you want a fighter, right? Isn't that what you would want? So there are different ways that lawyers can fight for you. The most obvious way is what we see sometimes in a courtroom, jumping up and down, screaming, yelling, and just being intense. They can be intense litigators. They can file motions, motion after motion after motion, contest everything, challenge everything the prosecution is doing. And then when you get to court, fight hard. Go after every witness who is providing evidence that gets you closer to being put in prison. That's what we're seeing right now inside this courtroom, ladies and gentlemen. That's what we've seen for the last 8 years from the defense team of Curtis Reeves. They are fighting for Curtis Reeves. Is he guilty? Is he not guilty? I don't know that. Only he knows that, right? He's the only one that knows exactly what he was thinking. A jury will figure it out, but he's the only one that knows. But you know he wants lawyers that are fighting for him. They've litigated this case to death. That's why it has taken 8 years to get to trial. That was part of the battle. Now you're seeing what they're doing inside the courtroom. And what surprised me was some of the reaction on social media. A lot of people are like, why are they doing this? This is obnoxious. This is obnoxious. And I read these comments because the comments from people who are watching the trial can be the same observations that are coming from that jury box. And it got me thinking today, is it possible that someone could be fighting too hard inside a courtroom and somehow that would create a bad impression, a bad vibe with the jury, that the jury is going to be turned off by the attorney fighting? And, you know, my gut tells me no, based on covering these big cases and watching lawyers fight. I think that's what we expect. That's why I was surprised by some of the reaction of people that were kind of taken aback by how aggressive this defense is. And they've been turning it up on cross-examination, turning it up in the opening statements. We'll know in a few days the impact of all this on the jury. But right now, I'm wondering, is this helping or is this hurting Curtis Reeves? Let's take a look at a little sample of what the defense has been doing inside that courtroom.
You looked at him, and he looked, his facial features were what?
Like a frown.
Like a frown, okay. And so, in addition to the frown, you say you heard mumbling, is that correct?
That's correct.
Well, did you hear what was being mumbled?
I did not.
Now, you would agree that since there's limited space in front of you, if someone gets up and he's walking in that limited space, you're going to say, excuse me, right?
I would.
And you certainly wouldn't say, excuse me, because the previews are playing and you have patrons all around you. You wouldn't say, excuse me. You would, in a very low tone, say, excuse me.
I would make direct contact with that person and I would go, excuse me.
But what if the individual's just saying, excuse me, as he walks by in a low tone?
He was not saying, excuse me.
Well, how do you know? You don't know what the mumbling was.
It does not sound like excuse me.
Both you and your wife are seated. You're paying attention to the previews, right?
Yes, sir.
You're looking to see what's coming up next that you may want to go see.
Yes, sir.
And it was your wife that had to nudge you to get your attention, to focus your attention on something else.
Yes, sir.
And when you did that, when she did that, you scooted up. Correct?
Yes, sir.
And the first thing that you see is you see a person standing up, correct?
Yes, sir.
And what you see is really a silhouette, right?
That's correct.
You don't see my definitions that you see here, right?
No, sir.
You don't see clear skin color, color of my eyes, right?
No, sir.
You don't see the color of my frames, do you?
No, sir.
All you're seeing at that distance is a silhouette.
Yes, sir.
You know what a silhouette is?
Yes, sir.
When you came, when the prosecutor was here, this is what you told the jury, that you called propped up. Is
Yes.
that what you call propped up?
Yes, sir.
Or was he leaning, as your statement, leaning over the back of his seat?
He was not leaning over the back of the seat.
Not leaning, even though that's what you put in your statement.
Yes, sir. You're correct.
You must have been lying then when you made
I
that statement.
object to that characterization.
You remember me taking a depo of you on July the 27th of 2015?
Yes, sir.
You remember that when I took your depo, you were placed under oath
Yes, sir.
and to swear to tell the truth and nothing but the truth, so help you God?
Yes, sir.
And were you telling the truth when I was deposing you on that date?
Yes, sir.
And do you remember the following questions and answer? Question, okay, he's rubbing the corner of his eye. Answer, correct. Question, not his eyelid. Answer, correct. Now, were you telling the truth back when I took that question and answer from you?
I was.
You didn't know the weight of the phone at that point in time, correct?
That's correct.
But you would agree that if that phone was being thrown at someone else, it's being used not as a phone but as a weapon.
It could be, yes, sir.
And you would agree that that phone can cause great bodily harm.
It could, yes, sir.
It can cause death.
It'd be difficult, but I guess anything is possible, sir.
It'd be difficult. Well, tell me why you think it would be difficult.
Because of jet.
He opened the door on it, Judge.
He's intense. He's absolutely intense, but is he over the top? Is he turning off the jury? Let's bring in Court TV crime and justice reporter Matt Johnson, who's joining us live tonight from Pasco County, Florida. Matt, great to see you tonight. Intense cross-examination, intense opening statements throughout. That's just the mode that this defense is in. Anything from that stand out to you? Any takeaways from the defense?
I think that was a good mashup. That's, if you haven't been following from day one, I mean, they're at like a level 10 every day, and it's like that all day when you're in court. No one's nodding off in the jury pool over there. I'm watching them. No one's falling asleep. And, these attorneys, sometimes they quote things, sometimes it's bad words. Everyone looks up. They don't need a microphone at the podium when they talk. And another thing that's been sticking out to me is the theme that we're starting to see, little breadcrumbs here and there, Vinny. They had 8 years to work on it, right? So right now, it's about the cell phone. We're hearing more about the cell phone. Earlier, it was the cell phone and the grainy video, and maybe the flash was the phone being thrown. And now we're also hearing yesterday and today about how the collection of evidence with the DNA and the cell phone. And then today, that it's a deadly weapon. Listen to this.
You didn't know the weight of the phone at that point in time, correct?
That's correct.
But you would agree that if that phone was being thrown at someone else, it's being used not as a phone but as a weapon.
It could be, yes, sir.
And you would agree that that phone can cause great bodily harm.
It could, yes, sir.
It can cause death.
It'd be difficult, but I guess anything is possible, sir.
It'd be difficult. Well, tell me why you think it would be difficult.
Because of jet.
He opened the door on it, Judge.
Death by phone, yeah, we are probably going to see that as a theme in closing arguments. Another thing to bring up here, before the state rested today, we saw 2 more witnesses take the stand, eyewitnesses. They both didn't see any fists or cell phones flying, that's their testimony, but one of the last witnesses did hear a gunshot and then a key word, popcorn. Take a listen.
You camera act that I was okay? Sure. I saw someone stand up, say something, text my daughter, and then like they reached to grab something and then throw.
Okay.
So it was something being crumpled. I didn't know what it was at the time.
Okay. And then what happened right after that?
Immediately after that, I heard someone say something along the lines like it's like it was mumbled, like they were mumbling. It said something like "show you," followed by like throw popcorn at my face. It was like more like declaratory, like out of anger.
Okay. And was it the same voice that mumbled and said throw popcorn?
Yes.
All right. So it was the mumbled part was from the same person that said throw popcorn at my face.
That's correct.
Did you hear the statement regarding "I'll show you" or "to throw popcorn at me" before the shot or not?
It was at the same time.
So it wasn't before the shot.
It was maybe a second difference. It was so close in time as far as when it was said and when the act occurred. It's really hard to recall exactly. It was maybe a half a second or a second within each other.
So that's going to be another key piece and a theme that we're going to hear a little bit more, especially in closing, Vinny.
Yeah, that is such a huge deal because you've got an instantaneous acknowledgement that, yes, it was popcorn. The popcorn creating the anger. Big problem for the defense. Matt Johnson down in Pasco County, Florida tonight. Thanks so much, Matt. Let's bring in our think tank joining us tonight in Los Angeles, California. Criminal defense attorney Lara Uretzian. In Houston, Texas, criminal defense attorney Carmen Rowe. And in Atlanta, Georgia, criminal defense attorney, law professor at Emory University and Georgia Innocence Project board member Molly Palmer. Great to see everyone tonight. Wow. Let me start with what I started with, and that is, you're all defense attorneys. You're all intense. I feel it every Thursday night, for goodness sake. Is there a line that you can cross that suddenly a jury gets turned off because you're going after ordinary citizens who are eyewitnesses and somehow you're beating them up? Or do juries see that as you fighting for your client? Lara.
Well, there is always a line that you can cross, but I don't think the attorneys in this case are crossing that line. I mean, they're just being great advocates for their client. I mean, some of the questions the attorney was asking, he was basically impeaching these witnesses. I mean, they said something different years ago or during interviews or in statements, and now suddenly that story has changed. Well, if he doesn't confront them with these, then it's malpractice per se. He's got to do it. And I don't think he's being obnoxious. I think he's doing the right thing. He's bringing up with weaknesses in the prosecution case, including the witness's ability to see clearly what was happening. I mean, he was saying you were seeing a silhouette. So I'm all for what they're doing. I think they're doing great. I'm guessing that some of the people who had comments about how obnoxious or how this was over the top are probably guilty voters, and that's why they're reacting the way they are.
They could be, Carmen, but it's palpable inside the courtroom. The volume, the tone, everything that comes with it. We heard it in the opening statements as well. In a case where your client is accused of being a grumpy bully, confronting people, could that be a problem?
Vinny, absolutely. And I think there is a line as well, but there's nothing linear about being a criminal defense attorney. You can be aggressive as a prosecutor in a different way than criminal defense attorneys. So being a defense attorney means being dynamic. It means pushing and it means pulling back sometimes. But I couldn't agree more that I think these lawyers are being aggressive in just the right way. I think that they're emphasizing things that are important for this jury to hear. And I think that they're digging in just like their client needs them to do, to get in there and say, look, this is where he was and this is how he felt in this moment. And I think this case is going to come down to these jurors understanding the fear that he must have felt that day. And I think all this dynamic, over-the-top aggression is part of the dynamics that we need to see in that courtroom. And I think, just like Matt said, I think everything's at a 10 in that room. And so it's congruent with everything else going on.
Yeah, I think if we want to use an example of where that line is, we would go back to the recording of this show about 2 weeks ago with Molly. And that's probably where the line, it's just about where the line is. Molly, let me ask you, I'm going to ask you a different question, okay? I want to talk about what Matt pointed out. which was a witness who testified about hearing the mumbler. This is the second witness now talking about Mr. Mumbles. The grumpy mumbler, okay, is mumbling about popcorn at the same time, within a moment of that gun firing. To me, that is an acknowledgement and admission that he knew that he had been hit with popcorn.
Well, right, and that's why these attorneys are having to be so aggressive with these witnesses that are just bystanders that, really you wouldn't expect the defense team to go after like this, but they're trying to show that they have credibility issues, that their memory is not exactly crystalline. So that way, when they make this argument that this bystander heard this statement mumbling followed by "I'll show you if you throw popcorn at me," if they can simultaneously show that that witness has credibility issues and his memory is not exactly accurate, then it helps their defense. And that's why they're going down these paths with all of these individuals who have taken the stand. And I think also the other thing, Vinny, is as a defense lawyer, you of course want to fight for your client, but you also want your client, not just the jury, but your client to appreciate your style and your approach. And I think it'll be so interesting if Curtis Reeves takes the stand tomorrow to see how similar he is to his counsel. I think that they have a lot in common, including temperament, approach, and disposition. So we'll see.
We shall see. All right, Larry Uretzian, Carmen Rowe, Molly Palmer, they're here the whole hour. When we come back, the